Hello everyone, hope you have an amazing day and welcome to my new blog. Today we discuss about Minimum Wages Act 1948. So the article discusses the objective, essential provisions and applicability of the Minimum Wages Act 1948. It also talks about constitutional validity of the act along with significant judicial pronouncements. So the act is introductions. The labor law in India consists of significant legislation such as the Industrial Dispute Act 1947, Payment of Bonus Act 1965, the Workmen Compensation Act 1923, Minimum Wages Act 1948, etc. So in the Indian Constitution, labor laws fall under the concurrent list, which gives power to both central and state government to legislate and make rules on the matter. So this legislation plays significant roles in protecting the rights and interests of the workers, providing employment opportunities to the workers, protecting employee from exploitations and creating a healthy work environment, etc. Now, the system of paying the minimum wages to the employee has been globally accepted as system to combat poverty and stabilize the economy also. The Minimum Wages Act 1948 was brought into force by Parliament of India in order to provide due remuneration to the workers and to prevent unfair exploitation of the workers by the employers in organization. The act lays down the minimum rates of wages and fixing of minimum wages rates for both skilled and unskilled labor and aims to provide a decent standard of living for them. The act grants power to both the central and state government to regulate, review and revise the rate of minimum wages paid to the employees employed in the scheduled payment or employment under their respective jurisdiction. The act does not discriminate between men and women. It pays all the employees equally for doing the same work in organizations. Now, understanding the term minimum wage, the International Labour Organization's ILO has defined the term minimum wage as the lowest amount of remuneration that an employer is required to pay wage earner for the work performed during a given period. That cannot be reduced by collective agreement or an individual contract. Around 90 member states of the ILO follow the provision of minimum wages. Now, the purpose of minimum wage is to protect the employers or workers from unduly low pay. It enables them to earn adequate wages for the work done by them and to maintain a minimum living standard also. So it also acts as a tool of eradicate poverty and to remove discriminations between men and women. So this system has been designed and developed in a way to supplement and reinforce other social and employment policies also, including collective bargaining, which is used to set terms of employment and working conditions also. In India, payment of minimum wages is regulated and administered by the Minimum Wages Act 1948, as I mentioned earlier. Since India offers one of the most competitive labor costs in Asia with the national level minimum wages at around INR 176, which amounts to INR 4,576 in a month. However, it is the national level wage which will vary considering the geographical locations and other relevant factors. In India, a complex method of setting a minimum wage is used which defines nearly 2,000 different types of jobs for unskilled workers and over 400 categories of employment, which provides a minimum daily wage for each type of job also. Now, we discuss in details of types of wages. So in 1948, a tripartite committee known as the Committee of Fair Wages was established. The committee report was to benchmark for the formulation of wage policy in India. The committee not only set guidelines for wages rate in the country but also laid down three kinds of wage, namely minimum wages, fair wages, and living wages. So, minimum wages, this is the type of wage provided for bare substances or subsistence so that the workers can maintain a decent standard of living, such as providing for education, medical requirements, and an adequate level of comfort. So, fair wage, any wage paid to the employee that are more than the minimum wage is known as a fair wage. So, it is the wage that seeks to maintain a level of employment in the industry and also look after the industry capacity to pay sufficient remuneration to the employees. Now, living wage. A living wage not only meet the minimum requirement of the employee provided by the employer but also allows individual or families to afford adequate shelters, food, and other necessities in their life. It also includes health, sanity, education, dignity, comfort, and provide for any contingencies also. Now, need for a meaningful minimum wage. Now we discuss about details. What is the meaningful minimum wage and its necessity? So in India, the minimum wage fixed for the laborer are so low, and that is not enough even for 2 meals a day. Leave aside the needs of health, education, and shelter. The main objective behind minimum wages of the worker should be primarily because of two reasons. Number one, social objective. So minimum wage is essential for abolishing poverty by providing a basic standards of living to the employees. And number two, economic objectives. The rate of minimum wage should be fixed in such a way that would motivate the workers to put a minimum effort at their jobs and thus improve the economy of the country and their standard of living also. So minimum wage legislation in India requires to active support of workers, trade unions, and labor associations. It would also require sincerity on part of the labor department in each state in order to determine the minimum wage rate on the basis of ethical and humanitarian concerns to ensure basic subsistence for workers is under organized sectors also. So ignorance and illiteracy are also the primary reasons for the exploitation of the employees in the unorganized sector. Now, trade union and NGOs can help by making the workers aware of the legal provisions of the minimum wage rate and the benefits to which they are entitled. Furthermore, minimum wage data is not readily available to the general public. Only limited official data is available from the National Labour Ministry website, which may or may not be updated regularly and in a timely manner. The information available does not permit extensive comparisons of wages in formal and informal sectors due to different formats of reporting or recording of wage rates in each state. Now, need of Minimum Wage Act 1948. Now we discuss about this. The Minimum Wages Act 1948 was enacted by the Indian legislature to deal with matters relating to providing the minimum wage to the workers so that they can afford their basic needs and maintain a decent standard of livelihood. The Act further ensures a secure and adequate living wage for all laborer, and it also guarantees that an employee earns enough to provide for his family, to maintain his family. So the act authorizes both central and state government in fixing the rate of minimum wages for the labor. The Minimum Wage Act 1948 has also laid down a provision for revision of minimum wages in order to cope with the changing prices of basic commodities also. So the act seeks to provide better protections of the rights of the employees by establishing advisory boards to resolve any dispute between the employer and employees regarding the payment of minimum wage to the employees also. The act further appoints a commissioner for workmen compensation or any other offers of the central government, exercising functions as a labor commissioner for any region. So with an experience as a judge, order to hear and decide, so concerning non-payment of less than the minimum wage to the employees. So the act also states provisions for penalizing any employer who fails to provide the minimum wage to the employer and contravenes any rule or order made under the act also. So thereby it can be said that the enactment of this act was extremely crucial, since it aimed to expand the concept of social justice to the workers of scheduled employment and also provide them with the rates of minimum wages fixed by the status. It also protects the rights and interests of the workers and prevents the workers from being wrongfully exploited by the employer also. Now the objectives of Minimum Wages Act, now we discuss in details. The significance of the Minimum Wages Act 1948 is mentioned right now. Number one, to fix the minimum rates and wages that are to be provided to the employee and revise such rates of wages every 5 years. Number two, to secure an adequate living wage for all the laborer in the interest of the public. Number three, to fix a daily working workers to the employees. Number four, to prevent exploitation of the workers by the employer. Number five, to ensure that the laborer can maintain a decent standard of living. Number six, to provide basic physical needs, good health and level of comfort to the employees also. Number seven, to penalize the employers when they fail to provide minimum wages to the workers. Number eight, to establish advisory boards to regulate and administer to the provisions of the Act. Number nine, to lay down the power and duties of the inspector for the purpose of this Act 1948, the Minimum Wages Act. Number 10, to prevent any employer from wrongfully infringing the right of any employees. Number 11, to establish appropriate authorizing or authorities where the employees can seek redressal when the employer has failed to pay the daily wages. Number 12, the authorized central and state government both to make rules and regulation for the purposes of this Act, that is the Minimum Wages Act 1948. Now we discuss in details about application of Minimum Wages Act 1948. The Minimum Wages Act 1948 is applicable to the whole of India is laid down in section 1 of the Act. It applies to any employment if it employs 1000 employees in the respective state. However, it does not apply to any employees in any undertaking owned by the central government or of the Federal Railway except with the consent of the central government. Now the essential provisions under Minimum Wages Act. The significant provisions of the Minimum Wages Act 1948 are now I mentioned. Minimum wages, minimum rates of wages. So under section 3 of the Act, the minimum wages payable, the employees are to fix by the appropriate government. However, these sections also mention that the rate of the wages shall be revised every 5 years. The appropriate government may fix the minimum rate of wages for time work, the minimum rate of wages for piece work, a minimum rate of remunerations to apply in the case of employees employed in on piece work for the purpose of securing to such employees a minimum rate of wages on a time work basis, a minimum rate of the wages to substitute the for the minimum rate which would otherwise be applicable in respect of overtime work done by employee. In fixing or revising minimum wages under section 3 of the act, different minimum wages of rates of wages may be fixed for different classes of works, different schedules employment, different localities, different age group, etc. It depends. So minimum wages may be fixed by the wages period, such as by the hour, by the day, etc. And section 4 of the Minimum Wages Act 1948 state that the minimum wages fixed by the appropriate government must consist of a basic rate of wages, and special allowances must be adjusted at necessary intervals by the appropriate government to match the cost of living of the employees. The cost of living allowances, that the cash value of the consensus or concessions in respect of supplies of essential commodities, must be computed by a competent authority and at such intervals specified by the appropriate government also. Now section 5 state that in order to fix or revise the minimum wages of the employees, that appropriate government may establish as many committees and subcommittees necessary to hold requires or inquiries in matter regarding fixing and revision of minimum wages. So further, the appropriate government by notifications to the official gazette published its proposals for the information of the individual who are likely to be affected by such informations, and hereby specify to date the date which must not be less than 2 months from the date of notifications of the proposals that will be taken into considerations also. Now advisory board under section 7, the appropriate under must appoint advisory boards for coordinating the work of the committees and subcommittees mentioned in section 5, and also for advising the appropriate government generally in matter of fixing and revising minimum rates of wages. Now central advisory board in the matter of fixing and revisions of minimum rates of wages of the employee, the central government shall appoint a central advisory board. The central advisory board shall consist of members to the nominated by the central government representing employers and employees in the scheduled employment, who shall be equal in member or number, and independent persons not exceeding or exceeding 1/3 of its total number of members. One such member shall be appointed as the chairperson of the Central Advisory Board. Now committee, section 9 of the Act states that members of the committee, subcommittees and advisory boards shall be appointed by the appropriate government also. Individuals who are appointed to these committees shall be representatives of the employers and employees in scheduled employment and shall be equal in number. The appropriate government shall appoint such an independent person to be chairman of the committee. Now wage in kind under the Act. So section 11 of the Minimum Wages Act 1948 mentions how the wages will be payable to the employee. Minimum wages under the Act shall be paid in cash. The appropriate government under necessary circumstances by notifications to the official gazette authorize the payment of the minimum wages either wholly or partly in kind. The appropriate government by notifications to the official gazette authorized the provisions for the supply of essential commodities at concessions rates. The cash value of the wages and the concessions rate shall be authorized in prescribed manner stated under the Act. The payment of wages to the employee under the Act should be done in accordance with section 12 of the Act, which states that the employer shall be paid the minimum wage of rate of wages fixed to every employee working under him within such time and manner prescribed under the Act. Now, fixing hours for a normal working days. Normal working day, Section 13 specifies that the appropriate government may fix the working hours of a normal day, including one or more specified intervals, provide a day of rest in every period of 7 days to all the employees or a class of employees, and adequate remuneration must be provided to the employees during the day of rest. Provide payment to the employees on the day rest, which shall not be less than overtime rate. When an employee works more than this specified number of hours constituting a normal working day, the employer shall be liable to pay him for every hour or part of the hour at the overtime rate fixed under this Act and under any law of the appropriate government for the time being in force. So furthermore, under Section 15, if an employee has worked less than the required number of hours consisting or constituting a normal working day, shall be entitled to receive wages in accordance with work done by him on that day, as if he has worked a full day over. However, he might not receive the wages of a full day under certain circumstances. Now, maintenance of registers and records. Under Sections 18 of the Minimum Wages Act 1948, every employer will be liable to maintain registers to record relating to the number of employees employed under him, the work done by him, the wages paid to him, the work performed by him, or to maintain receipts given by the employer and any other relevant informations also. Now, inspectors. In this Act, the appropriate government, by notification to the official gazette, shall appoint inspectors in a manner prescribed under the Act. The inspector shall be liable to exercise these functions within a local limits of their jurisdictions also. The inspector shall enter the premises or places within the local limits of their jurisdictions. So whether the employer or employees are employed to work in respect in which minimum rates of wages have been fixed under this Act for the purpose of examining the register records and wages, etc. also. To examine any person on the premises or place who is an employee, cease to take copies of registered records of wages or other required documents under this Act which may consider relevant in case of commission of any offense. The inspector will be required to exercise or any other power as may be prescribed under this Act. Every inspector under this Act will be deemed to be public servant within the meaning of the Indian Penal Code 1860. Now, claims the appropriate government may be notifications to the official gazette appointed by the Commissioner of Workmen's Compensation or any official of the central government exercising functions as a labor commissioners of any region with an experience as a judge. When an application under Section 20 of the Minimum Wages Act 1948 is made to the authority shall be given adequate opportunity of being heard of both the applicants and the employer under these sections. Every directions of the authority shall be binding the final. The authority appointed under the Act shall have the power of a civil code under the Code of Civil Procedure 1908 for the purpose of taking evidence, enforcing the attendance of witnesses, productions of documents, etc. So that's for the video, my friends. If you like my videos, please subscribe my channel and share comments on my channel. Thanks a lot for watching my videos.